The morning I found the snowmobile tracks running through my father's pine plantation, I was doing what I did every morning in winter on that property, which was walking the fence line with coffee in a thermos and the specific attention of a man who had inherited 46 acres of northern Wisconsin timberland from his father 3 years prior and who understood, because his father had told him repeatedly, and because he had come to understand it himself, that the trees were not just trees. They were 31 years of his father's work. The plantation section occupied the northeastern 18 acres of the property. White pine, Norway pine, and a section of Scotch pine along the eastern boundary, planted by my father Gerald Hutchins beginning in 1991 when he had acquired the land and continuing through the next decade in phases that corresponded to his retirement from the mill and his increasing investment of time in the land. He had planted most of them himself, he and my mother in the early years, the two of them working rows on weekends and school holidays with the planting bars and the seedling bundles from the state forestry program. I had planted some of them as a teenager. I knew those trees the way you know things you have put into the ground yourself. The snowmobile had entered through the eastern fence line at a point where the wire had been pushed down, run a path through the plantation section that was not a trail and had never been a trail, covering approximately 900 linear feet of travel through the trees, and exited through the western boundary fence at a similar push-down point. The damage was not subtle. I counted 14 trees down. Not fallen from snow load or wind, down from impact. The bark on the standing trees adjacent to the track showed strike marks at snowmobile height, the specific scraping pattern of a machine moving at speed through a space with insufficient clearance. 3 of the 14 downed trees were snapped at the base. 4 had root systems pulled partially from the frozen ground where the machine had driven over or clipped the root collar. 7 had trunk damage severe enough that even if they did not fall immediately, they would not survive to the following season. I photographed everything. I measured the track width. I measured the damage radius around each affected tree. I identified the entry and exit points and photographed the fence damage at both locations. Then I walked the full track twice more, once with my phone recording video, and once with a paper notebook where I wrote down every observation in the methodical way my father had taught me to document things worth documenting. My father had been a methodical man. He had kept records of every tree he planted, species, planting date, location on a hand-drawn grid map that he updated annually. He had marked each row with a numbered stake system and had maintained a log showing the health assessment of each tree from the time it was planted through the last year of his life. I had those records in the farmhouse. I knew the planting date of every tree in that plantation. I went inside and pulled the relevant grid sections. The 14 affected trees had been planted between 1993 and 1997. The youngest was 26 years old. The oldest was 30 years old. I called my friend Marcus Webb, who was a licensed forester and who I had been consulting on the property's timber management since I inherited it. He drove out that afternoon. He walked the damage with me and said nothing for a long time, which was his way of processing things, and then he said, "David, I need to do a formal damage assessment." I said, "How long?" He said, "I can have a preliminary figure by the end of the week, full documentation 2 weeks." I said, "Do the full documentation." He said, "This is going to be a significant number." I said, "I know." He said, "The market timber value of trees this size is one component. The replacement cost is another. The ecological and aesthetic value of a 30-year plantation is a third. Wisconsin has specific statutes on timber trespass that allow for multiplied damages in cases of intentional or reckless destruction." I said, "I know the statute." He said, "You've been doing your homework." I said, "My father taught me to do my homework." He said, "Good man." He was. My name is David Hutchins. I am 48 years old. high school biology teacher in Madison, Wisconsin, and the inheritor of my father's 46-acre property in Vilas County in the northern part of the state. I had been driving up on weekends and school breaks since I inherited it, maintaining the fences, managing the timber, keeping the farmhouse functional, doing the things my father had done and that I had watched him do my entire childhood, and that I had come to understand were not chores, but a relationship with a piece of land that deserved tending. The property was in Vilas County, which was snowmobile country. I understood that northern Wisconsin in winter had a snowmobile culture that was real and genuine and deeply embedded in the recreational identity of the region. There were designated trails, county-maintained corridors, easements through willing landowners' properties, and a community of riders who knew the trail system and used it responsibly. My property was not on the designated trail system. It was clearly posted with no trespassing signs at regular intervals along all four boundaries, signs I had installed and maintained specifically because snowmobile trespass was a documented problem in the county and because the plantation section was not terrain that snowmobiles should be in. The signs were visible. The fences were intact before the trespass. Someone had made a deliberate choice to push through my fence and cut across my property. I drove the perimeter road that afternoon looking for any indication of where the machine had come from and where it had gone. The eastern entry point connected to a road that ran along the county road system, accessible from multiple directions. The western exit point opened onto a snowmobile trail corridor that was part of the county system. So someone had come off the county road system on the east, cut directly through my property to connect to the designated trail corridor on the west, shaving what I estimated was about 1.5 miles of distance compared to the designated route. A shortcut. Someone had destroyed 14 of my father's trees for a shortcut. I drove the county trail corridor westward from my exit point for about 2 miles, following the designated trail that someone had decided was too inconvenient to use, and I stopped when I reached the parking area at the western end where trailers and trucks were parked during riding season. I sat in my truck and looked at the parking area. There was one trailer parked there at that time of day, a two-place snowmobile trailer with one sled loaded and one space empty. I noted the plate. I drove home and called the Vilas County Sheriff's Office. The deputy who took my call was a man named Corporal James Hendricks, who worked the Northern District and who had the specific quality of a rural county law enforcement officer that had dealt with snowmobile trespass before and understood its seriousness. He said, "How much damage are we talking?" I said 14 trees down or mortally wounded. The formal timber assessment is in process. My preliminary estimate, based on Wisconsin timber trespass statute, is in the range of $30,000 to $60,000, depending on the assessment methodology. He was quiet for a moment. He said 30 to 60,000. I said the trees are between 26 and 30 years old. They are not saplings. They are mature plantation pines approaching commercial harvest size. The timber trespass statute in Wisconsin allows for double damages in cases of reckless destruction. He said, "You know the statute." I said, "I looked it up the morning I found the damage." He said, "Mr. Hutchins, I am going to come out and look at this today." He came that afternoon. He walked the damage with me and photographed everything independently. He examined the fence damage at the entry and exit points. He asked about the plate number I had noted at the parking area. I gave it to him. He said, "I am going to run that plate and I am going to talk to some people. The trail corridor on your western boundary connects to a network that has a pretty well-known local riding community. Someone will know who is running that section today." He said, "Mr. Hutchins, I want to manage your expectations on timeline. Criminal trespass investigations in rural counties move at their own pace. The damage assessment is going to be important for establishing the severity of the offense. I said, I understand. I am not in a hurry. I want it done correctly. He said, that is the right attitude. He left. Marcus Webb filed his preliminary timber assessment 3 days later. I want to describe what a professional timber assessment of a 30-year plantation looks like, because the numbers require context to understand. Marcus assessed the 14 affected trees using 3 methodologies. The first was stumpage value, which is the market value of the timber standing in the forest. White pine and Norway pine of the size and age affected had a documented stumpage value in the Vilas County timber market. 14 trees of that size had a combined stumpage value of approximately $4,200. That number sounds modest, but stumpage value was not the relevant measure under Wisconsin timber trespass law. The second methodology was replacement cost, which assessed the cost to replace each destroyed tree with a nursery specimen of equivalent size and install it properly. There are no nursery specimens of equivalent size available for 30-year plantation pines. The largest available nursery specimens are 8 to 10 feet tall and take 20 to 25 additional years of managed growth to reach the size of the trees that had been destroyed. The replacement cost calculation therefore included the cost of nursery stock plus the present value of 25 years of management, maintenance, and lost timber production during the gap period. The replacement cost per tree ranged from $8,000 to $12,000, depending on species and size. 14 trees. The third methodology was aesthetic and ecological value, which assessed the contribution of the affected trees to the plantation's overall value, character, and ecological function. A plantation with a 900-foot scar through it, with 14 gaps in what had been a continuous canopy, had diminished aesthetic and ecological value beyond the individual tree losses. Marcus's full report combined all 3 methodologies and arrived at a total damage assessment of $87,400. He noted that the Wisconsin Timber Trespass Statute, specifically Wisconsin Statute 26.09, allowed a plaintiff to recover double the assessed value of timber unlawfully cut or destroyed, bringing the potential recovery to $174,800 if double damages were applied. I read the assessment twice. Then I called my attorney. My attorney was a woman named Susan Park, who practiced property and natural resources law in Madison and who had handled my father's estate and the property transfer when he died. She had grown up in northern Wisconsin and knew timber law specifically. I told her the assessment number. She said $87,400. I said, with double damages potential of $174,800. She said, Marcus Webb did the assessment. I said, yes. She said, Marcus's assessments hold up. He is thorough and his methodology is defensible. I said, I know. She said, David, has Corporal Hendricks identified anyone yet? I said he called yesterday. He has a person of interest. The plate I noted at the parking area is registered to a woman named Kathleen Morse, who lives in the county. He has obtained trail camera footage from a private camera at the parking area that shows a single snowmobile departing in the direction of my property approximately 90 minutes before I found the damage. She said, a single rider. I said, a single rider. She said, do you know anything about Kathleen Morse? I said I looked her up. She is the president of the Northwoods Riders Association, which is the local snowmobile club that maintains the trail corridor adjacent to my western boundary. Susan was quiet for a moment. She said, the president of the snowmobile club that maintains the trail corridor took a shortcut through your plantation. I said, that is the working theory. She said, David. I said, I know. She said, a club president who knows the trail system took a shortcut through posted private land and destroyed 14 trees in a 30-year plantation. I said, that is what the evidence suggests. She said, file date. I said, when Corporal Hendricks has confirmed his identification, I want the criminal investigation to develop before we file civil. She said, agreed, keep me posted. Corporal Hendricks called me the following Friday. He said, Mr. Hutchins, I have confirmed my identification. The individual is Kathleen Morse of Mercer, Wisconsin. I have trail camera footage from 2 separate cameras showing her machine on the route consistent with entering your property, and I have a witness who observed her at the parking area before and after the time frame of the damage. I said, what is the status of the criminal matter? He said, I am filing a criminal complaint for criminal trespass and criminal damage to property. The damage assessment supports a felony-level charge given the dollar amount. I am also consulting with the District Attorney's Office about the application of the timber trespass statute. I said, thank you, Corporal. He said, Mr. Hutchins, I want to tell you something. I said, go ahead. He said, I have been doing this work in Vilas County for 16 years. The snowmobile community here is generally responsible. What this individual did was not an accident, and it was not a navigation error. Your property is posted. The fences were intact. She pushed through a fence on posted private land and drove through a plantation. He said, that is going to be taken seriously. I said, I appreciate that. He said, your documentation was very helpful. The photographs, the measurements, the planting records. Having the planting dates for the individual trees was something I have never seen in a timber trespass case. I said, my father kept records of every tree he planted. He said, he sounds like he was a good man. I said, he was the best man I knew. That was the end of part 1. The criminal complaint was filed. The civil complaint was being drafted. And Kathleen Morse, president of the Northwoods Riders Association, was about to receive a set of documents that would communicate precisely what her shortcut had cost. Part 2 is where the bill arrived, and where the full weight of 31 years of my father's work was placed on the legal scale. Karen tore through my property on a snowmobile and destroyed my father's pine forest. She never expected the massive bill waiting for her. Susan filed the civil complaint on a Thursday, 2 weeks after Corporal Hendricks filed the criminal complaint. The civil complaint was 41 pages. Susan had built it with the thoroughness of someone who had grown up in the region she was litigating in and who understood both the legal framework and the cultural weight of what had happened. She cited Wisconsin's Statute 26.09 specifically and invoked the double damages provision. She attached Marcus Webb's full $87,000 assessment as an exhibit. She attached my father's planting records showing the individual planting dates of each affected tree. She attached my photographic documentation, Marcus's documentation, and Corporal Hendricks's field photographs. She also included something I had not asked her to include, but that she said belonged in the complaint. She included a section that described the nature of the property and the history of the plantation. She described my father planting the first trees in 1991. She described the family labor that had gone into the plantation over the following decade. She described the state forestry program seedlings and the planting bars and the weekend work. She described my father's annual health assessments and the log he had maintained for 30 years. She described the fact that I had planted some of those trees as a teenager. She said the plantation was not a commercial timber investment. It was a 31-year family project that represented the working life of a man who had died 3 years prior and whose trees had outlived him until someone destroyed 14 of them for a shortcut. I read that section twice. Then I called Susan and told her it was right. She said, the law allows economic damages. The narrative allows the court to understand what those damages actually mean. I said, my father would have appreciated that. She said, tell me about him. I told her about Gerald Hutchins. about the mill where he had worked for 22 years, and the retirement that gave him the time to become the person he had always wanted to be, which was a steward of northern Wisconsin timberland, about the state forestry program and the seedlings and the weekend planting that had been the organizing project of his retirement, about the annual walks through the plantation where he would stop at certain trees and tell me about the year he had planted them and what the weather had been and whether it had been a good year for establishment, about the planting records that documented everything. She said he would have kept those records forever. I said he kept records of everything. He said that a man who doesn't write things down is a man who doesn't believe the things he does matter. She said he was right. She said, David, I want to prepare you for the possibility that Kathleen Morse does not have the personal financial resources to satisfy a judgment of $174,000. I said, I have thought about that. She said her homeowner's insurance may cover some of the liability, but intentional trespass is often excluded from coverage. I said, is there any other avenue? She said the Northwoods Riders Association. If she was conducting any association business or using association equipment when the trespass occurred, the association may have institutional liability. I said she was the association president. She said, riding the trail corridor adjacent to your property, which is the corridor the association maintains. I said, and taking a shortcut across my property to connect to a different section of the corridor. She said, whether that constitutes association business is a question worth asking. I said, ask it. Susan sent a formal legal inquiry to the Northwoods Riders Association and its board requesting documentation of Kathleen Morse's activities on the date of the trespass, the association's liability insurance policy details, and any trail modification discussions that might have involved the route through or adjacent to my property. The association's response came through an attorney hired by their liability insurance carrier. The carrier was taking the inquiry seriously. Susan said, the carrier is involved. That means the association has liability insurance that covers member activities related to trail operations, and the carrier has determined that this situation is at least potentially within coverage. I said, what does that mean practically? She said, it means there is an insured party with resources. The discussion changes. The criminal matter developed on its own timeline alongside the civil case. Kathleen Morse was charged with criminal trespass and criminal damage to property under Wisconsin statute. The criminal damage charge was elevated to a felony level based on Marcus's assessment, putting the damage well above the misdemeanor threshold. She retained a criminal defense attorney named Howard Webb, who appeared at her initial hearing and entered a not guilty plea. The criminal proceedings moved at criminal speed, which is slower than civil. The civil negotiation moved faster. The Northwoods Riders Association's insurance carrier assigned an adjuster named Richard Park, who called Susan 6 weeks after the complaint was filed. He said the carrier had reviewed the complaint and the supporting documentation and had some questions. He asked about Marcus Webb's methodology for the replacement cost assessment. Susan referred him to Marcus directly. Marcus spent 2 hours on the phone with Richard Park and his consulting forester explaining the methodology. Richard called Susan back and said the consulting forester had reviewed Marcus's methodology and found it defensible under Wisconsin timber valuation standards. Richard said the carrier is prepared to discuss settlement. Susan said the complaint number is $87,400 in compensatory damages, with double damages applicable under Wisconsin Statute 26.09, for a total of $174,800. Richard said the carrier's position was that double damages were a judicial determination and not a guaranteed outcome. Susan said the statute was clear and the documented intentional trespass supported the application, but that she was willing to have a conversation about the structure of a settlement that accounted for that uncertainty. They talked for an hour. Kathleen Morse's personal attorney joined the negotiation because the complaint also named her individually, and her personal homeowner's policy had a separate coverage question. Her homeowner's carrier declined coverage on the intentional acts exclusion. Kathleen Morse had no insured coverage for the personal liability. The negotiation, therefore, involved the Northwoods Riders Association's carrier, covering the association's institutional exposure, and Kathleen Morse personally covering her individual exposure. Her personal exposure was the portion of the damages attributable to her individual conduct, as opposed to any institutional role. Her personal resources were limited. Susan said, "David, I want to talk about what settlement looks like in practical terms." I said, "Go ahead." She said, "The association's carrier is prepared to offer a significant settlement on the institutional side. Kathleen Morse personally has limited assets. A judgment against her personally that she cannot satisfy is technically a win, but practically difficult to collect." I said, "What does the institutional settlement look like?" She said, "The carrier has authority to settle at $90,000. That covers the full compensatory assessment from Marcus's report and approximately half of the double damages potential." I said, "90,000 from the association." She said, "Plus whatever we can negotiate from Kathleen personally." I said, "What does she have?" She said, "Her home has equity of approximately $40,000. She has vehicle assets. Her retirement accounts may be partially accessible depending on the judgment structure." I said, "Susan, I want to ask you something." She said, "Go ahead." I said, "Is there a way to structure the personal component so that it is paid over time in a way that is collectible and documented?" She said, "A structured payment agreement with a judgment lien on her property." Yes. I said, "How much personally?" She said, "Based on her disclosed assets, a realistic personal component is $30,000 to $35,000 through a structured payment." I said, "That puts the total at $120,000 to $125,000. She said, "Yes." I said, "The double damages potential was $174,800. She said, "Yes." I said, "What is your assessment of achieving the full double damages at trial?" She said, "Strong case, but trials have uncertainty. The offered settlement represents 70 to 75% of the double damages potential with certainty rather than uncertainty." I thought about that. I thought about my father and the planting records and the 31 years of work and the 14 trees lying in the snow. I thought about what he would have said about a certain settlement versus an uncertain larger number. My father had been a practical man. I said, "Accept the structure. 90 from the association, 32 from Kathleen in structured payments with a judgment lien." Susan said, "Total 122,000. I said, "Yes." She said, "I will proceed." The settlement was finalized 6 weeks later. The association's carrier issued a check for $90,000. Kathleen Morse signed a structured payment agreement for $32,000 over 4 years, with a judgment lien recorded against her property. The criminal matter resolved separately 3 months after the civil settlement. Kathleen entered a plea agreement on the criminal damage charge, reduced to a misdemeanor through the plea, with a fine, probation, community service, and a restitution payment that overlapped with the civil settlement amount and was satisfied by it. She also resigned as president of the Northwoods Riders Association. The association's board sent me a letter following her resignation. It was signed by the new president and 2 other board members. It acknowledged the damage that had occurred, expressed the association's regret, and stated that the association had adopted new protocols requiring that all club members confirm their routes for any ride were on designated trail corridors before departure, and that any modification to trail routes required board approval and landowner consultation. The letter also said that the association had reviewed its trail corridor map and had identified my property as a location where they had previously discussed potential trail easements, and that any future discussion of easement possibilities on my property would be initiated through formal channels with respect for my position as landowner. I wrote back thanking them for the letter and noting that I would be willing to hear any formal easement proposal they might develop in the future, though I made no commitment to any arrangement. Marcus Webb came out in the spring to assess the plantation. We walked the full track of the trespass together. He said, "The stumps will take years to rot down." I said, "I know." He said, "You could plant replacements in the gaps." I said, "I am going to." He said, "It will take 30 years to reach what was lost." I said, "I know that too." He said, "Your father's original plantings are still standing on either side of the track. They are in good health." I said, "He planted them well." Marcus was quiet for a while. He said, "David, the settlement number, how do you feel about it?" I said, $122,000. He said, "Is it enough?" I thought about that. I said, "No number is enough. Those trees cannot be replaced in my lifetime or my children's lifetime. But the settlement is a documentation of what was lost. It says these trees had value, that the work of planting and tending them for 30 years was real, that destroying them had consequences." He said, "Your father would have wanted the documentation." I said, "He always wanted the documentation." He said, "The planting records made the case." I said, "The planting records made everything. Without the planting dates and the species identification and the grid map, Marcus's assessment would have been estimates. With them, it was documentation." He said, "Gerald Hutchins kept records." I said, "Gerald Hutchins kept records of everything he did that mattered." We walked back through the plantation on my father's original trails between the rows, the ones he had kept clear for his annual assessments, the ones I had been maintaining since I inherited the property. The trees on either side were tall and straight and healthy. 30 years of standing. I planted the first replacement seedlings that afternoon. 12 bare-root white pine from the state forestry program. Same program my father had used in 1991. I planted them with a planting bar. I recorded each one in my father's grid system. Species, planting date, location. Here is what I will leave you with. My father spent 31 years planting, tending, assessing, and documenting a pine plantation in northern Wisconsin. He did not do it for financial return. He did it because he believed that a man should leave something growing where nothing was growing before, and because he found in the work of tending trees the specific satisfaction of a project that outlasted individual seasons and individual years, and asked only for patience and attention, and the willingness to come back every year and see what was there. The planting records he kept were not for lawyers. They were for him. They were the record of the years and the work and the specific location of each tree he had put into the ground. When 14 of those trees were destroyed for a shortcut, the records became something else. They became evidence. They became the foundation of an $87,000 damage assessment. They became the basis of a $122,000 settlement. They became the documentation that said these trees existed, that they had been planted on specific dates in specific locations by a specific man, and that destroying them had a cost that could be measured and collected. Keep your records. Not for lawyers. For the work itself. For the things you plant and tend and care for. For the evidence that what you have built is real and has value and deserves protection. And if someone destroys what you have built, the records will tell the story. My father's records told it completely. Drop your thoughts below. If someone has trespassed on your land and damaged timber, crops, or anything you have cultivated, tell me about it. And if you own timberland and have not documented your trees, start with your state's forestry program. Most states have free resources for private land timber inventory. Start the record today. Because the records are the case. And the case is worth building before you need it. End of part 2, approximately 7,100 words. Thumbnail text. She took a shortcut through my father's pine forest. The bill was $122,000.